Start. In order to satisfy ourselves, we had summoned the relevant record, which has been produced by the learned additional chief standing counsel, and on a perusal thereof, we find that after submission of the reply by the petitioner to the charge sheet, no date was fixed by the inquiry officer for holding any inquiry, nor any inquiry was held by him, No material has been produced before us by the learned additional chief standing counsel showing any inquiry having been held by the inquiry officer as is required under law, It appears that the inquiry officer has prepared and submitted the inquiry report straight away after submission of reply by the delinquent, The documents placed before us by the learned additional chief standing counsel reveal that the inquiry officer issued a letter dated 18.7.2011 annexing therewith the charge sheet to the petitioner seeking his reply to the same by 10.8.2011 By the said letter, the petitioner was also required to inform as to whether he wanted any personal hearing and also if he wanted to examine and cross-examine any witnesses, then the name as also a brief note on the points, on which such examination or cross-examination, was required, It was stated that if the reply was not submitted, then it would be deemed that the petitioner had nothing to say in respect of the charges and accordingly the inquiry would be conducted and the state government would be informed, The contention of the learned additional chief standing counsel that as the petitioner did not state in his reply that he wanted any personal hearing, nor did he mention the name of any person, whom he wanted to examine or cross-examine, therefore, the inquiry officer prepared the inquiry report and submitted the same before the state government, Learned additional chief standing counsel contends that sufficient compliance of the rules of procedure as prescribed under law has been made for imposing major punishment and principles of natural justice were duly adhered to, We are able to accept the contention of the learned additional chief standing counsel, even if the delinquent employee does not request for personal hearing, the burden of proving the charges normally being upon the department, the inquiry officer was under obligation to fix a date for such inquiry with information to the delinquent and to conduct inquiry wherein he was required to examine documentary as well as oral evidence in support of the charges, Even if the delinquent employee did not participate in the inquiry, the inquiry officer was duty bound to discharge his obligation as an inquiry officer of ascertaining the truth in respect of the charges levelled against him on the basis of evidence as to whether the same are proved against him or not, Even if the delinquent does not demand personal hearing or does not give the names of witnesses with brief synopsis of points on which he wishes to examine or cross-examine the witnesses, the inquiry officer is not absolved from fixing a date of inquiry with intimation to the delinquent, In either eventuality, he is required to hold inquiry, if delinquent is present, in his presence, if he is absent, ex parte, If oral evidence is referred in the charge sheet, same is required to be recorded / examined, if not, Even then, the documentary evidence is required to be examined in the light of the charges of ascertaining the truth in respect thereof, full stop. The delinquent is also entitled to be intimated the date for oral inquiry, comma, wherein the inquiry officer should confront the delinquent with the charges and the evidence in support thereof, comma, put relevant queries to him, comma, elicit and record his replies oblique response in respect thereof, full stop. Such oral inquiry is necessary as it gives an opportunity, comma, to the delinquent to explain his conduct and to the inquiry officer to have a better perspective of the controversy, comma, as, comma, it is not always possible to discern the truth from written replies and documents which may not necessarily convey the complete truth. Since the bona fide mistake has already been corrected and the experts have examined and evaluated the final key answers to the questions of all the option papers, comma, it has been urged that no interference is called for with the opinion of experts, full stop. It has also been submitted that if a wrong answer is taken as correct or vice versa, then the same would be true for all the students and it would not prejudice the interest of any of the candidates, full stop. In support of his such submission, comma, Shri Baghel has relied upon a decision of the apex court in the case of HP Public Service Commission versus Mukesh Thakur 2010 AIR SCW 3636, full stop. It was lastly submitted on behalf of the commission that no right was conferred on the candidates who had been declared successful on 1.6.2011, comma, hence after the declaration of the revised result in which they were declared unsuccessful, comma, there was no question of granting any relief to them, full stop, over.